It is my great pleasure to introduce today's keynote speaker, Natalia Bielova. Natalia is a tenured research scientist at INRIA, where she leads research on privacy and data protection on the web. Natalia approaches this with a multidisciplinary lens, combining elements of both computer science and law. In particular, from 2021 to 2022, she was a senior privacy fellow at the French Data Protection Authority, where she spearheaded research with an aim towards establishing privacy-focused regulations for protecting personal privacy data. She is the recipient of numerous awards and accolades, including the 2018 Young Researcher Award from the French National Research Agency, INRIA Doctoral Supervision in Research Awards in both 2017 and 2021, the Best of ACM Chi Honorable Mention Award in 2021, and the Rising Star Award by Women at Privacy in 2023. Today, she joins us to share her firsthand experiences working at the intersection of privacy, security, law, and policymaking. Please join me in welcoming PETS's first keynote speaker, Natalia Bielova.
Does it work? Yeah, okay. Thank you very much. It's really my pleasure to be here at PETS. Thanks a lot for the invitation. And I'm really happy to see so many familiar faces in this room right now. So I'm going to talk about the transdisciplinary research between computer science and law and how this can help to improve privacy. So this is a joint work with many fantastic PhD students, interns, and postdocs, and collaborators, without whom this work would not be possible at all. So a little bit about myself. I'm soon to become a senior research scientist, which is equivalent to full professor at INRIA, which is a French Institute in Mathematics and Informatics. And I worked for the French Data Protection Authority, the CNIL. So you will hear a lot the word CNIL in my talk today, for 1 year in 2022. So my research interests are in large-scale web privacy measurements, but also in the European data protection law and how it applies to the web technologies, and also dark patterns and user manipulation. So when we talk about web tracking, we always imagine that the user goes to the web and starts visiting various websites to order a pizza, to check the weathercast in Bristol, and to book an appointment. And of course, the trackers then are present on this website, and they start collecting profile information about these users. So the more the user goes on the web, the more these profiles are collected. So we have hundreds of such third parties, and we have billions of websites that a lot of different users are visiting. And we have to always think about the end users. We have around 5 billion worldwide connected to the web. So the research in this area of web tracking has evolved a lot in the last 10 to 15 years. There are really numerous web tracking technologies that are used to track people. So it started with an analysis of third-party cookies. Many of you worked in this room here on this topic. Browser fingerprinting, cookie respawning, synchronization of cookies. And nowadays, we have even more sophisticated techniques like CNAME clocking, navigational tracking, and other techniques like server-side tracking. You will hear about these techniques in PETS in the last session, in the last day. So all these technologies are actually there, and we as a community are continuously building new tools to detect web tracking. So I've been told to discuss the challenges for the research community. It's my second slide, and you already see one big challenge we have today is to develop the new tracking detection tools, because we know that third-party cookies are going to be deprecated, so the community has to actually adapt and find new ways to detect tracking. But when we started looking ourselves into this field, we saw the very first work on analyzing tracking behaviors in the paper of Francisco Rosner and others back in 2012. So that was the first approach to analyze trackers by looking at the behavior of of the various content that gets loaded on our pages. And this was very inspiring, at least to me, back in 2012, to actually start looking deeper into the problems of web tracking. And that, for me, this was also a turning point where I actually switched from the previous domain of research to web tracking, because I really liked this paper. So with my student, we started looking into what can be actually a very good indicator that web tracking is happening on a page. And we found out that this could be invisible pixels. How many of you heard about pixels? Yeah, so today everyone knows what the pixels are, right? But back in the 2019, 2018, when we started looking into this, there was not much work on analyzing the tracking behaviors that are actually lead to loading of these pixels. So that's what we did, and that was actually, proudly speaking, my first PETS paper. It was 2020. So we decided to do quite a typical research on web tracking. We would crawl the web, we would find all the requests and responses, and we would log all of this. We collect more than 600,000 cookies and analyze what kind of images are loaded on the page. And then taking all this data that we had and also taking a lot of inspiration in the first taxonomy of tracking behaviors, we built our own taxonomy. So I'm not going to bore you with the details about the taxonomy of all the different groups, but I want to show you one specific behavior that we found and was new at the moment. So this behavior is called first to third party cookie syncing. So let's imagine we have the web browser where the user is visiting a website, and there is a cookie database with some cookies from DoubleClick, and we have a very typical scenario where the script from Google Analytics gets loaded on this page. What will happen here is that the analytics script will set the cookie in the browser, and this will be first-party cookies. Here its value is 1 to 3. And a very typical behavior of the Google Analytics would be that the request will be sent to Google Analytics with this identifier, allowing Google Analytics to know that the user 123 has visited this site. This is a very normal standard behavior of analytics tools to identify how many different users have visited a specific website. What we saw is that there are also one additional request that allows a company, so in this case DoubleClick, to actually know that it's the same user who is visiting, so the user who is identified as 456 here for DoubleClick is the same one that's the user 123 that is known by Google Analytics. So why is it interesting? It's only one request. Well, actually, this one request allows to synchronize the within-site trackers and the cross-site trackers. And we have found this type of behavior on 68% of the web. And what's even more interesting is that we found that most cookies have been synchronized in this way between Google Analytics domain and DoubleClick domain, both owned by Google. So back in the time, it was a very interesting discovery. We found a new behavior that synchronizes cookies. It was a very nice publication at PETS. But a few months later, I saw a sanction coming from the CNIL, the French Data Protection Authority, against Carrefour. So it's a big supermarket chain. You don't need to know French to understand what's written in this decision. So basically what was found is that there is a first-party cookie from Google Analytics. There is a synchronization of this cookie with the cookie from DoubleClick. So it's exactly the same kind of behavior we have found in our research. And that the consent is needed for this type of synchronization. And it was not there on the website of Carrefour. So when we saw this decision, we thought, wow, if only we had some kind of a browser extension or some kind of a crawler that we could give to the regulator, they would have found this type of behavior on all the 68% of the websites we have found. They would make decisions. They would, just sanction all these companies who are collecting and synchronizing the user's data. Well, we actually made the browser extension in the end. It's still in a prototype phase, so many regulators would not be able to use it, and this is a typical result of an academic publication where we have a very nice prototype that looks good for us, but it will take years until the regulator or any other user can actually understand and use this type of tools. But I'm happy to talk about it further if you want. So since then, in my group, we decided that it's very important to help regulators to protect users' privacy, and we want to actually get closer to the needs of the regulators. And so the way we think about it is that, well, the website publishers, when they build the websites, they insert this kind of tracking and advertising content, and the user's data is collected. But in Europe, we have the GDPR and the privacy regulation that are actually trying to control and regulate all this space. So we have regulators who are auditing for compliance of the websites, but they are also looking into all this tracking and advertising ecosystem as well. And at the same time, they have to ensure free and informed consent of the user. But moreover, all of this ecosystem is continuously changing. So the regulators are actually making new binding decisions. They are providing new interpretations to the law. The websites are changing continuously. Our browsers get updated. And all of this change in the ecosystem make the advertising and tracking industry also change their practices. So we have to think about the tools that will allow us to continuously monitor this change that's happening across all the systems. So today I'm going to talk about transdisciplinary research. So it started, of course, with a very typical research on large-scale web privacy measurements that many people in our community have been doing. But we asked ourselves a question. So how web tracking is actually regulated with the data protection laws? How can we approach closer to this regulatory compliance when we are building our tools and when we are detecting web tracking at scale? Well, the first answer is we have to look in the law itself, right? So we have in Europe the e-privacy directive. How many of you heard about the privacy directive? Oh, that's great. OK. Yeah, so back in the time, we'd look at the privacy directive and say, OK, so what do we have there? Well, actually, Article 5.3 there is talking about storing information or gaining access of information of the terminal equipment of the user. That's allowed when the user has given his or her consent. And then there is also, in green, there is also some kind of exception. And we'll talk about that in a minute. So the consent is required. And then what does it mean that the consent is legally valid? Well, actually, here it comes with GDPR. And GDPR has also its own requirements on consent. But when we computer scientists started reading this text, we said, OK, that sounds nice. Consent is freely given, specific, informed, and unambiguous. But then what does it mean concretely? And additionally, we have other requirements for consent in Article 7 of the GDPR that talks about the withdrawal and also about the clearly distinguishable from other matters and intelligible and is easily accessible. So these are nice high-level requirements, but what do we do when we see a consent banner on a BBC website? I want to draw your attention to the bottom of the banner, not to the top. Right? So, and that's exactly typical user behavior. We don't want to see the banners. We just want to get the news, right? But if we actually pay attention to the banner and we ask ourselves a question, how do we know whether this banner is compliant with the law? We have no way to know. The law itself doesn't give us a direct answer to this question. So to get the answer, we have to collaborate with legal scholars. And that's what we started doing in my team. So I had a fantastic law collaborator, Cristiana Santos, who started telling me, well, actually, you have to look into the binding case law, so the law itself, but also all the decisions that were made at a very high level. So for example, the European Court of Justice, which is the highest court in Europe, but also the decisions in every country in Europe to see what kind of consent was considered compliant and what not. On the other side, we also have non-binding case law, which are the guidelines and best practices and sometimes examples of violations. But the problem there is that we have every European Data Protection Authority that will come up with their own guidelines. So right now, we have this bunch of guidelines that talk about cookies. And when regulators say cookies, they actually mean cookies, all the tracking technologies, consent, cookie banners, all these topics are actually covered under the magic word cookies that for us computer scientists has completely different meaning. Okay, so that's already very difficult. So we started looking into this back in 2020. And actually, we delivered a talk together with Christiana at HotPets in 2020. When I asked her this question, how do we verify that the consent banner is compliant? And she said, oh, you need to be an expert. Otherwise, there is no way to know. And please check. We have now 75-page draft paper in which we actually decompose all these requirements for a cookie banner compliance. So we have finished that work, and we have published this in a legal journal. And basically, we have mapped these high-level requirements of GDPR valid consent to 22 low-level requirements by analyzing all these binding and non-binding sources. But sometimes we also had to sit down together and decide whether a certain requirement makes sense or not based on our own interpretation from the law or from the computer science perspectives. Okay, and for each requirement, we also understood that the auditing for compliance can be quite different. Sometimes it can be automated. Sometimes we need quantitative user studies. For example, to analyze whether the consent is intelligible or if it's readable and accessible. There is no way to know this with automated tools. We need to understand how users react to those type of consent banners. And sometimes we need manual analysis. Around the same time, we also saw that companies now provide consent banner as a service, and that gave rise to the new type of companies called consent management providers that today is an active area of research. I see several papers here at PETS analyzing that. So we have now hundreds of these companies who are providing consent banners. So when we saw that, we understood that we can actually already make the first step towards automated auditing of consent banners, because this kind of consent mechanisms are implementing the IAB Europe Transparency and Consent Framework, which is an industry standard for implementing consent. So this allowed us to actually look inside the consent that's stored in your browser and analyze whether it's compliant with the actions of the user. So we found that there are many websites where consent is positive and it's stored in your browser before you even interact with the banner. And we even found websites where you say when you say no, I don't want to be tracked, and actually you have a positive consent stored in your browser. So what does it mean that the consent is positive? Well, it's just one signal that allows around 600 different advertisers as third parties to get your data. So based on these results, the NGO NOIB has filed complaints to the French Data Protection Authority, the CNIL. So they used our results and they used our browser extension. So we don't have an official answer from the CNIL about this case, but we believe that we have a lot of impact because most of the websites we reported has fixed their practices, and you can see the historical videos here. So this was the first step towards automated auditing of compliance. But is it possible to fully automate the compliance with the data protection laws when we are analyzing websites and we are detecting web tracking technologies? So let's take a step back and think again about the legal requirements. So we have said that the ePrivacy Directive requires consent, and GDPR defines when consent is valid. But actually, there is this exception that I mentioned. And in law, actually, it's never so straightforward as we would like it to be. In practice, we have always plenty of exceptions. And if we want to automatize compliance auditing, we have to take them into account. So web tracking technologies require consent unless they are used for communication or they are strictly necessary to enable the service requested by the user. This sounds very legalese, right? What does it mean in practice? How do we know that a certain technology is used for communication or is strictly necessary? Well, to be able to automatize that, we need to know the purpose. And this is quite I think it's quite understudied for the moment. So for each tracking technology we detect, let's imagine tomorrow you crawl the web, you found, oh, this is a new way that users are tracked. How do you know what's the purpose of that technology? So in a very preliminary study, we tried to find the purposes of cookies, right? So third-party cookies, they've been everywhere for many years. And we found that only 13% of them are even mentioned in the cookie policies. Luckily, just a few years ago, there was a new paper at Usenix where the researchers proposed a classification mechanism for cookies to actually map them to purposes. It's called cookie block. And they used 4 purposes that are strictly necessary: functionality, performance, analytics, and advertising. And these are very common categories of purposes that are used by many content management providers. Yet, there will be a paper presented, I think, today, also at PETS, discussing how users react to these purposes when they see them and whether they actually understand what these purposes mean. But that's another problem. So from a very technical perspective, we have to understand what's the purpose of each tracker, and we have to build further tools to identify and to map them to the purposes, because this is actually a building block for both research community, if we want to analyze compliance, but also for the regulators. So once we understand what's the purpose of each tracking technology we are detecting, now which one of them actually fall under the exception, right? And which one are not? Because I imagine if I actually run a company, I would say, oh, all the technologies I'm building and I'm using are actually going to fall in the exception, so no consent will be needed, I'll be fine, no compliance problems for me, so that's great, right? So when I asked this question to my legal scholar colleague, well, the answer is this. Go back again to to the law, to all the decisions, to the case law, to the non-binding law, because there is no definite answer right now to which purposes are definitely requiring consent and which ones are not. I actually believe there is another legal paper that should come out on this type of topic, because it's quite commonly believed that advertising purpose requires consent, even though some of the regulators may still argue about that. For the analytics behavior, like the example we've seen with Google Analytics, there are actually in Europe quite divergent opinions about whether these type of analytics tools require consent or not, and it depends on the conditions in which these analytics tools are employed. And in my team, we try to even measure what the tracking and advertising companies are declaring, for which purposes they are going to use consent and for which one not. So we looked back at the IAB Europe Transparency and Consent Framework, where all the advertising and tracking companies are actually registering themselves, and they are declaring which purposes they are going to use and for which ones they're going to use consent. And here on this figure here, you'll see that for each of these predefined purposes, the opinions of the third parties actually differ. Some of them think that consent is needed, for example, for personalization, while others are saying, no, we are not going to use consent. We are going to use, it's a different legal basis in GDPR. It's called legitimate interest. We are just going to use that. We're not going to rely on consent. So there is actually here a legal and technical challenge in analyzing which purposes actually require consent and how can we convince regulators to actually converge so that we can build then automated tools and check for compliance automatically. Okay, so this was the part on the analyzing compliance of web tracking when we think about the tracking technologies, but there has been also a lot of research, including our own, on the compliance of consent banner interfaces and implementations. So when regulators are trying to regulate the consent banner interfaces, we have very similar pictures. So on one side, we have binding decisions. So every country again in the EU, but also at the European level, will make case law decisions deciding that, oh, this is not a valid implementation of a banner. For example, there was a case against Google because there was no refuse button on the cookie banner interface. Since then, this became a common knowledge that the refuse button is needed. However, as you will see later, some regulators still don't really agree with that. On the other side, we have non-binding guidelines, which represent the best practices. So these actually are described in the consent banner interfaces most of the time in plain language, saying the interface should have that button and should not have this other button, or we had actually a lot of fun analyzing those guidelines. And in the middle, we have the gray zone banners. And that's what we find a lot on the web. These are basically banners that are neither violating the law nor best practices. They are gray zone. And most of the time, these are exactly the type of banners that would contain manipulative dark patterns that try to manipulate users into making decisions they would not make otherwise. On top of that, this space is also changing all the time. We have continuously new decisions. We have continuously new best practices. And that's why analyzing this gray zone is actually quite difficult, because it depends on all this legal context. We have done one work in this direction. So we try to understand what is the behavior of the user when they are interacting with the banners. So we have found that how to represent the consent task flow, and what are the different what are the different steps that the user take, and how in each step, what are the legal requirements for consent that actually need to be respected, and what are the dark pattern strategies that that can occur at every step. So when we were doing this work, we actually understood that there are many different dark patterns naming conventions, and people are using various types of dark pattern literature to map the requirements of consent banners to dark patterns. And so we decided to analyze all those sources. So just between 2018 and 2023, we had a lot of academic taxonomies on dark patterns knowledge, so what kind of practices actually represent dark patterns in general, but also there was a lot of interest from regulators. So we have European Data Protection Board, we have European Commission, OECD, FTC, that came up with their own classifications of dark patterns. And we said that that's very interesting, because the same practices may be called in different ways in these taxonomies. So we decided to actually analyze all of that. So we mapped all these dark patterns definitions, and we have 245 different patterns, and then we grouped them, and we came up with the ontology of dark patterns knowledge that I invite you to use, because it actually contains links to all the original definitions. So in pink, you will see here the academic taxonomies, and in the blue are the regulatory taxonomies. And we unite all those under unique naming conventions, and we propose unified definitions for dark patterns. Actually, we just received great news that the Spanish data protection authorities has cited this work in their guidelines on detection of dark patterns in Spain. Okay, coming back to the regulation of consent banner interfaces, we actually also decided, so a parenthesis, when I was at the CNIL, I understood that many different regulators still think differently about how we should regulate these consent banners. So since around 2019, we had numerous guidelines from the European Data Protection Board and then from many European regulators. So in total, we had around 16 different regulatory guidelines that we decided to analyze. So we actually sat down together with my legal scholar colleague, and we have read those guidelines and tried to identify what are the different consent banner interfaces that these regulators consider to be compliant. And on the other side, when I was at the CNIL, I was also asked to explain what is the research that has been done on the impact of design on the user decision-making when they are interacting with consent banners. And I actually found a lot of papers that you will recognize some of yours here, that look into the cookie banners, and they try to test different designs and see how one change in the design will impact the decision-making of the user. So in this work, I have analyzed 11 user studies coming from the HCI domain, from security and privacy, social computing, and I even found the very first report done by the European Commission itself in 2016 when they actually also did a similar kind of study. And these studies also come from different countries. So we have studies from the US, from UK, from Germany, and others. So we decided to actually try to map these two groups of studies, right? On one side, we have best practices from regulators, and on the other side, we have user studies that say that kind of design will impact the decision-making, and this is statistically significant, right? So we have tried to bridge these two worlds together by reasoning about each different aspect of the cookie banner interface separately. So let's have a little quiz time. So which consent banner do you believe is compliant? So if we only think about the lower part of the banner, we don't care about what's written on it. We just analyze at this moment the accept and the reject option. So we have accept all, decline all option. We have accept all with a cross sign. And then we have accept all. And then this is a kind of a BBC banner that we are seeing here. Clicking here, you can know more, and you can decide to, maybe you can reject. OK, so who believes that the first banner is compliant? OK. Who believes that the second banner is compliant? All right. Who believes that the third banner is compliant? Oh, wow. Oh, that's unexpected. OK. Well, maybe because we have a very mixed audience from many different countries and the regulations are different. I don't know. I'm curious now. So actually, the first banner is considered to be compliant according to many European regulators. They say accept and decline has to appear on the same, on the first layer. And so this comes from French, Spanish, Luxembourg, and many other DPAs. Second banner is considered to be compliant according to Italian and Latvian DPAs. Why? Because in GDPR, we have privacy by default and by design. And because of that, you are not supposed to have any tracking technologies before you interacted with the banner. And if you close the banner, you didn't make any choice, which would correspond to the fact that you didn't give your consent, which means that, again, no tracking should happen. So we already see a divergence among regulators. And then the final one is only supported by the Irish DPA. OK. Yeah, so many people may guess why is that, but we don't know for sure. And this only allows to, it says there should be some information provided to the user that rejection is possible. So this already shows that the European regulators don't agree even with each other on what kind of consent banner is compliant. So how can we researchers actually know how can we measure compliance at scale? I mean, I know there are many attempts, and I know we can take like the most common interpretation, but I wanted to let you, to expose this audience to the fact that actually, depending on the country, these results may be relevant or not. And so then when we try to bridge this gap between the regulatory compliance and the user studies, we found many different gaps. So for example, a very typical gap is that the guidelines will require disclosure of different type of information, and this comes from the GDPR transparency principle that says the user has to be informed about all the cookies that are present on the site, or how many of them, and all the purposes, and so on and so forth. And this is often presented in the main text of the banner, but we actually have user studies that say there is no significant effect on the banner's text, on the user decisions. Some researchers even tested the structure. Someone tried to, compare the plain text to structured text, bullet point list. None of that make any difference for the users. The users don't see the text. And so we wanted to show to regulators that maybe something should be done there. We don't need so many requirements. Users don't look at that. We also found different insights for researchers. So we believe that the research community should also be more aware of the different requirements that come from the regulators and make user studies that are closer to the needs of the regulators. So for example, we found that, we found only one guideline in the EU that have presented some kind of very few guidelines in the EU that presented a visualization of a potentially compliant cookie banner. Most of them described what the cookie banner should look like in a plain text. That was very difficult then to map. So when we found this example from Luxembourg Data Protection Authority, we found it quite interesting that basically they propose to, again, you don't need to understand French, it's just about the design here, so that we have purposes that users can select and deselect, and we have one validation button that would just validate this choice of the user. On the other side, we have seen some studies in our community that take the consent banner provided by, in this case, by OneTrust, and this banner was considered the best practice in the paper. So if we look closer, we actually see that we have the purposes similarly to Luxembourg that we can check, but we have allow selection and accept all cookies. So we will have two buttons. One, allow selection, that we believe corresponds to this choice of the user, so it's kind of similar to the validation button of the Luxembourg DPA, but we also have accept all, which facilitates the acceptance of everything at once, and that's definitely not the best practice and not the most compliant banner as the data protection authorities in Europe would require. Again, this gap could appear due to the fact that this particular study was made in the US, so there was no such requirement to look back at the European regulators. But I think I would like to invite the community, whenever you are running such studies, to try to get closer to the best practices of the regulator and call it best practice in your paper, and then evaluate what kind of designs you want against that best practice. So in total, we found 11 gaps for the EU regulators and 5 insights for researchers. I'm not going to present all of them here, but I invite you to read our paper that has just been published at the Harvard Journal of Law and Technology. And yeah, that was my second publication in the legal journal. So when I was at the CNIL, at the same time, we decided to run our own study to try to evaluate the impact of the design on the user's decisions. And we found out that back in the time, there was no study for a French population. And we also wanted to test some specific banners that we thought were very interesting. So in this work, we have looked into various cookie banner designs. So our control banner, or the best practice, contained the accept all and the decline all buttons. Then we, of course, included several dark patterns. So a very typical case is where we don't have a decline option on the first interface. This would correspond to actually the third choice that in our quiz, for which many of you have voted. Here we have the decline option hidden on the second layer. So we consider it to be dark pattern. It's very hard for users to find this option. And finally, we have also tested different new patterns. We believe that it's important to actually test what kind of behavior the users will have if we try to expose them to something new. So we took the legal requirement that the users have to be informed about the consequences of their choices, and we have interpreted this requirement very literally. So we just took the button text, and we said, okay, we are going to just inform them of the consequences directly in the banner, in the buttons that they will be paying attention to. So we have tested these banners with the more than 4,000 users in France, and we found out that actually on this figure you will see the refusal and personalization rate. So the refusal rate will be in blue. And we found out that this banner with the consequences actually makes the biggest impact on the refusal rate of the users. We found that around 47% of them actually would refuse any tracking with respect to the 17% that we would see in the control banner. What's interesting about this case is that when I present this type of results to the economics audience, the economist would tell me, yeah, but does it really, what does it correspond to? I mean, you found that the difference between the control group and this kind of banner that users interact with, they have been actually nudged towards rejection. So we also run other evaluation of the user satisfaction with the banners, and we found that they are most satisfied when they are interacting with this type of new patterns. We also have included a survey in our study where we found that around 31% of users actually don't want to be tracked, and they declared before running the study that they want to share any data about themselves. And so this 31% would come closer to the new patterns that we have tested. We also wanted to see how these kind of designs impact the decisions of the users in the future. So we have run our test 3 times. User visited 3 different websites, and they were presented 2 times with the banner that we want to test. And on the last step, they were all seeing a control banner. And then we have analyzed what is the user behavior in this last step. So if there was no impact of the design of the banners that the users have seen 2 times, we would see that the behavior of all the users in the last step is the same, right? Well, that's not what we found. We actually found that the refusal rate of the users changes significantly depending on what kind of interface they have seen only 2 times. So for example, for the banner with the consequences of their choices, we found a statistically significant difference. So the users actually, when they see this kind of banner 2 times, and then they come back to seeing a control banner, their behavior already changed. And it changed, basically the refusal rate increased 2 times. So this paper has been accepted at the Usenix Security Symposium this year, but we believe that we need, in the community, much more work on analyzing how users actually change their behaviors when they're exposed to different dark patterns or specifically to the consent banner designs over time, because this is what actually happens when we browse the web. Also, another conclusion we drew is that, at least in Europe, users have been exposed to cookie banners for so long, and these cookie banners have had dark patterns, and they didn't propose any option to refuse for so long that now their behavior in the control group is no longer the neutral behavior. We can no longer consider it as a treatment. So we as a community have to change the way we are doing research in this field, measure the impact of this kind of designs on a long term, but also change the way we reason about neutral design and our users. All right, so this work has, as I said, we have published in multiple venues, so in a lot in computer science, but also in the legal journals and conferences. But that was not limited to publications. We also actively gave feedback to the regulators. So when we saw that the regulators are publishing new guidelines, for example, on cookies and other trackers, we have actually responded to their public consultations. So what does that mean? How many of you have responded to public consultations of regulators? OK. So the regulators are providing a new document. They're going to write, for example, a new guidelines on cookie banner designs. And they make these guidelines public, and they search for any inputs from the community. So at this point, we would intervene. We would write our own document, what we think is right or wrong in the proposed guidelines. And when I was at the CNIL, I actually learned that the regulators are reading all these inputs very carefully. So we as researchers don't know that, right? We don't have any feedback, and we would like to get feedback. But there is no such procedure. But regulators are actually sitting down, and they're reading carefully each specific input, and they're deciding what's relevant and what's not relevant for these guidelines. So we have done substantial work on that. And maybe as a feedback loop, we can see that regulators cite our research. So we saw that, and again, for the legal scholar, this is a very big achievement, that the Belgian Data Protection Authority actually cited our paper in their decisions when regarding the IAB Europe Transparency and Consent Framework. We have recently saw a Spanish Data Protection Authority citing our research. And we found also that the Californian Privacy Protection Authority published a list of different academic resources they have checked when they were updating CPRA, and we found our paper there as well. So I think this shows that the research that we are doing, and that actually many people in this audience, I think, are doing, is great and is really helpful for regulators. I invite you to read this new paper that just came out at IEEE Security and Privacy, because this group of researchers analyzed a lot of different sources of literature, and they found that 270 computer science papers actually investigated the impact of privacy laws, and this is only between 2017 and 2023. So I think our community is growing. We are actively engaging with regulators, and I'm super happy to see that. OK, so a little bit about the perspectives. So I think we have to continue doing transdisciplinary research. And we call it transdisciplinary because we are actually stepping actively in the field, in another field than our own. I've been doing this a lot with the law scholars. I know some colleagues who have also done this with economics scholars. And we need to collaborate together. Very active areas of research are still needed. Very active research is still needed in the area of dark patterns, but also in the analysis of the roles and capabilities of different actors in the ecosystems that we are studying, because these roles and capabilities will define the legal obligations of various actors. And this is the kind of research we are doing right now. We are looking into the actors who are involved in the advertising ecosystem and trying to see how can we reason about the manipulation of these actors. Because these various actors are not just users. They are also website publishers. They are also advertisers or content management providers. We need to have more research with social scientists, or what we call user study research in our field, to further evaluate the various great design practices, and not only build our tools or provide or build our user studies, but actually provide these insights back to the regulators. We have to consider cultural and background differences among users, and also evaluate the impact on most vulnerable users. Because at least in European law, we had a lot of coverage for average users, but in practice, we know that we have a lot of different users who are really vulnerable that need to have dedicated studies. Finally, maybe an advice for a regulatory impact of your research. So we need to do more automated compliance auditing, but that requires a deep knowledge about the legal requirements. When I was at the regulator, I understood that regulators actually often prefer manual verification. When we're making decisions, they very often need to double check that everything is really consistent and before the decision comes out. But don't get discouraged. I think the large-scale study still are needed. They are really helping the regulators to define their enforcement strategy. So we actually have just presented this year to the Dutch Data Protection Authority, who is actively building their strategy, and they wanted to have all the studies that were done on web tracking. I believe that the user studies are really needed as well. We need to consider them as potential evidence for the regulators, even if the regulators are not yet agreeing with me on this. But I would like to say that the various tools we are building and various studies with users we are doing should be considered evidence. We need to look into more reproducible research. So our tools, our crawlers, our browser extensions have to be reproducible easily between ourselves, but also they need to be developed in such a way that the regulatory bodies can rely on them as well. And finally, please reach out to regulators in your country. They really need to know about your research. Present your results. So you probably heard about Federal Trade Commission PrivacyCon, but we now have a similar event in Europe. So it's a CNILS Privacy Research Day that I have helped to organize in 2022. And this event is still running until now. Collaborate also with different fields, with LOIC and economics scholars. And finally, I think we should also look beyond data protection law, because there are many other laws that are also aiming at protecting users, like consumer protection law, competition law. And in Europe, now we have this big package on on the Digital Services Act, the Digital Markets Act. Happy to talk about this with you if you're interested. We are looking into that as well right now. And I think I'll finish my talk with saying that in autumn, we're going to be hiring one new team member for the new team that I'll be building. So please reach out to me if you're interested in this type of research. Thank you.
Thank you so much for your talk. We have time for questions. If you have questions, I think there are folks with mics. So please find them, or maybe raise your hand.
Thanks for your talk, Natalia. Since I happen to also work on compliance questions, right? I think one question that I struggle a lot with, right? Even if with some of the work that we work on, we are successful, right? We're measuring non-compliance get fixed. You mentioned it, there's competition, or there's consumer protection, or there's EU Digital Services Act, there's Digital Markets Act, there's AI Act, there's, dozens of other articles under the GDPR that I think rarely get looked into right now. So it very much feels like an uphill battle to cope with that. So, what do we do? How can we even navigate the space and help ensure compliance?
Thanks. Yeah, so I think that indeed, in my talk, I covered only one aspect of GDPR, that was consent, and only in one context, which was web tracking technologies, right? Even though for computer science, it's already a very big field of research, but from the legal dimension, it's just one context with one application. So indeed, there are many other areas of GDPR that needs to be analyzed. So there are several researchers looking into data minimization principles and trying to provide computational models for data minimization. That I think is also another example of a truly transdisciplinary research. In the paper I've mentioned, there are really interesting outcomes on the quantification of how much research were done in different areas. So I don't know. I think to answer your question, we need to collaborate with those legal scholars. And we need to understand what are the various requirements that are there for the specific systems we are analyzing, right? Because again, for them, this is one application domain. For us, it's our whole field of research. So I don't know if that answers your question, but I think, I mean, for me, I've actually been to an event recently where we had law, economics, and a bit of computer scientists that got together and try to explain to each other what are the different problems in their fields. And it's really hard because, again, everyone is concentrated in their own area. But I think finding those people with whom you match on the topic and the common interests, I think, is the key. Yeah.
Again.
Yeah.
Hello. Oh, so you talked a lot earlier on about the ephemerality of a lot of these interfaces and artifacts, and I was just curious if you think that there is, that's something that occupies my mind a lot, which is how do we record what these things were, and do you think it's important to, or there's another way we should be thinking about documenting the interfaces that exist, that existed, things that did well or did not, because, you know, based on what you shared, there's a challenge in, especially in the consent interfaces, for example, where they're explained in text, but there aren't a lot of visual examples. Do you think that there's a place for systematizing the documentation, or maybe even an inventory or a database of these artifacts to help, you know, whether it's developers or regulators or whatever, understand what's out there, what has been out there, and maybe where we should be headed?
Yeah, I think it's a great suggestion. I mean, when you started your question, I was thinking about this research on Wayback Machine and how the web evolved and all of that. But actually, that's not what you meant. So what you meant is that you would like to record the evolution of the regulatory and guidelines, right, over time. Yeah, I mean, I think in an ideal project, we would like to have maybe both, to see how the guidelines evolve and classify all of that, and also to see how the web evolves, and then to compare the two. That would be great. I mean, this is a great idea. So to answer your question, yes, I think this is super interesting. But also to see how the regulators converge or diverge over time, I think this has not been done so far.
So my experience in the United States is that there's a small group of people active at this intersection of cybersecurity and law and privacy and law. And they're all they're faculty. But my experience with postdocs is that it's very hard to get postdocs from social science to do tech-informed social science, whether it's international relations and cybersecurity policy or privacy and so on. And it's even harder for the graduate students because, of course, they need positions in a department. What's it like for students in Europe I realize you're in France rather than in Europe, but I think that's part of our responsibility as we do this research.
Yeah, thanks. So for my own students, some of them are here, I think that we still, we work with them, we publish in computer science events because they do need that, right, for their graduation, for their postdocs. But I think I try to incentivize them to actually go and talk to the regulators and to present their results so that they understand the importance of their work, and then they are even more motivated to do very applied research, but with the goal to get closer to the regulatory requirements. So this is about the students. I think about the career. For me, ideally, we need to have we have to have groups where we have mixed backgrounds, right? So ideally, we would take a department of computer science and a department of law and make these kind of joint groups where people would evolve in their career in their corresponding departments, but at the same time, they would actually collaborate very closely. And I've seen this in some of the institutions. I've seen this at MPI. I think this is already happening. I think some of the faculty here that I know have actually gone through that type of training when they were exposed to computer science and law problems, and this helped a lot. I don't know if that answers your question, but I was asking the same question at my own institute, saying, can we actually hire here a law scholar, because I would really like her to be here? And they said, yes, but how would she evolve in the law if she is hired in the computer science department, right? That would not be possible, and it would not be beneficial to this person. So the best way is to have these departments together and then have joint groups who would work together. I think in COSIC it's already, in Leuven it's already the case. So I think that there are some models in Europe where this is happening, and yeah, I think we should do more.
Unfortunately, I think we have time for just one more quick question, and then maybe we can take the questions into the break.
Okay. Is this on? Yes. Okay. Yeah. I just wanted to ask, in doing research, user studies with cookie consent banners, I've sort of become jaded about improving these banners and actually getting people to meaningfully consent in this context. And I'm just curious what your thoughts are on like automated solutions like GPC or Global Privacy Control. I know that's been sort of accepted or mandated as being accepted in under California's privacy law, but I don't know how other regulators feel or what that looks like.
Yeah, I think the GPC is a really great approach, and looking back at my own paper from 2020, I found that we already made a conclusion that if we had a signal that would just say no by default, that signal could be reusable across many different websites, and this would be legally, it would make sense. But actually, as of right now, I'm trying to write a kind of a short paper explaining how the signals like GPC could be potentially compliant with the European requirements. But by talking to regulators, I see that it's still not really the legal requirements of consent are actually so specific that it's hard to bridge this gap between the specific requirements on the purposes to this kind of signal that will be that would just say no to everything. I mean, this is from regulatory perspective. From the user perspective, even in our own study, we asked the users, would they like to have a browser extension or something like that would just, automate their consent decisions? And then majority said, of course, that's exactly what we would like to have. So, yeah, I hope it answers your question. Thank you very much.
Thank you.